Right, well, welcome everyone to our Business Friday, and today we're going to be looking at the Employment Rights Bill. Bright and early on a Friday morning, and it's great to have you all with us to hear some more about this bill. And for those of you that haven't met me, I'm Catherine and I look after the employee relations at ECA. I'm joined today by Anabelle and Vicky. Anabelle and Vicky are our partners from Worknest, and as you can see there, have a long history of working with employment law and in the industry. Vicky is an employment lawyer and also works at doing the industrial relations for Hinkley Point, so has good knowledge of the industry. And Anabelle is head of organisation development services, working with lots of trade associations and doing lots of great learning across those organisations. What you'll really like about them, and what I like about them both, is that they have a real ability to talk about complex employment law in really simple terms. And I think that when you're dealing with an employment rights bill of 150 pages with 28 policies, that's really key to sort of get to the grips with what's happening, what's coming down the path in real practical and simple terms. And that's what we're really going to try to do for you today. So what we thought would be useful before we get into the actual detail of the policies is to just put the whole thing into context for you. Where's this bill come from and how has it been formed? So you might have heard terms like a new deal for working people or the Labour's plan to make work pay. And they are the names of the papers that originated the bill. So we started with the Green Paper in September 2022. And it was a paper that was written by Labour and their affiliated trade unions. And it was quite radical, really, in terms of what was contained in it. It had words like outlawing fire and rehire, banning 0 hours contracts. It had employment rights from day one, with no mention of any probation period. So what they were suggesting in that paper was huge. It was a big shift and change in employment law. It also had, though, that it was going to make flexible working a day one right, and that they wanted £10 an hour as the national minimum wage. So it needed to be revised, and it was revised, and in May 2024, and this is after Rishi's called the general election, so I'm taking you back some there, we got Labour's plan to make work pay, which I think with a real prospect of coming into government, rounded some of those more severe absolute terms. So instead of banning fire and rehire, the word exploitative was introduced. So it wasn't sort of outright bans or outright outlawing, and there were sort of terms and conditions that were introduced to achieve those aims, but not to ban them. So that was an interesting shift. Although at this point, it was still a paper that was co-written by their affiliated trade unions with very little business input into that paper. And then we moved to the manifesto, and we were interested to see, well, is this going to move the paper forward any? And actually what the manifesto said was, within 100 days of government, we are going to implement Labour's plan to make work pay, which they then did in October 2024, which we like a government to commit to their manifesto pledges. But in this case, what it meant was that that employment rights bill enacted Labour's plan to make work pay with very little consultation or input. So if we can move to the next slide. So what that meant was that we had 4 early consultations which closed last year on sick pay, fire and rehire, industrial relations and 0 hours contracts. ECA have worked behind the scenes on those consultations on behalf of members in terms of feeding back areas where we think need to be reviewed, because in terms of will this bill get passed through Parliament, you can see in front of you 411 Labour MPs that were elected at the general election, which means that the ship is setting sail, and you know, this bill can get through the parliamentary process. What we need to be thinking about are areas that we can influence. What can we influence the government to change? Where are the unintended consequences within this bill that haven't been thought through that perhaps we can start to influence? It's a big bill. It's 150 pages. It's got 28 separate policies. Now, we aren't going to go through 28 separate policies with you today, but we're going to focus on the main areas that we think that you need to build up knowledge for, that don't need secondary legislation, that might come down the road faster than the others, because you need to build up that knowledge now. And although the detail isn't finalised, we know from this slide alone that the likelihood of the policies becoming enacted is huge. So the bill is essentially employees will get more rights, and whether you think that equates to employers will pay more money, the Labour government will have you believe that this will give you a stronger, more protected, the ability to retain your workforce, and ultimately more productivity. The bill doesn't apply to Northern Ireland. They have their own Good Jobs Bill going through their parliamentary process at the moment as well. Next slide, please. So what is the parliamentary process? Well, this is what it looks like. This is where we're at now. We've gone through the committee stage and we're at the report stage. That happens next week. There have been amendments, so we have all fed back into those four consultations. There have been amendments at committee stage, but they were very technical amendments, so nothing that really changes the nature of what was laid out in the bill. One item that was introduced at that stage was the ability for employees to bring an employment tribunal claim with a 6-month period as opposed to the 3-month period that we currently have, but all the other changes were minor. So we are hoping at report stage now, and this is the stage that can bring about change, that some more response to the consultations will be put forward. So we think that the bill will achieve royal assent. That's to go through all those processes in the House of Lords. And the final stage is to achieve royal assent, we hope, late spring, early summer, and then it will become an act of Parliament. So what does the timeline look like? There is a paper that accompanies the bill, and it's called Next Steps to Make Work Pay. And the good thing is that when the act becomes a bill in late spring, early summer, it doesn't mean that all 28 policies are going to be live, if you like, and you have to enact all these 28 different employment law policies. Some require secondary legislation, so won't be ready to enact. Some will require further consultation, but there are some that are ready to go, if you like. Things like flexible working, which we will touch on today. But as the steps to make work pay tell you, the reforms won't be any earlier than 2026, and in particular, the unfair dismissal, which we will talk about today, will take effect no earlier than autumn 2026. So it's good to have these timelines. It gives businesses time to prepare, and that was the thought process behind the sort of timeline. They aren't just going to spring out at you. And we, of course, at ECA and with the support of Worknest, will guide you through those steps online and through our helpline. Next slide, please. So what we're going to cover in the session today, we're going to look at the key changes on the horizon that are going to impact your business. That's the day-to-day practical implications on your business. And we're going to try and talk you through some considerations that you can take now as a business. So obviously step one is to build up knowledge, and that's one of today's aims, to get you to understand what's happening, but then to reflect back on your current practices, maybe a review of what you're doing, and to sort of start to consider how you might implement the things that are sort of on the horizon. So really sort of trying to get some practical thoughts to you today as well. And so the focus, the main area, so I said there were 28 separate policies. We could have listed them all, but I think that would be sort of overwhelming. So the key focus for us today is to look at the employment rights section. So we're going to look at unfair dismissal protection, which currently sits at 2 years, and the bill is hoping to take that to 0. So we'll look at what that means, what the impact of that will be, and how you might start to practically look at steps to sort of counteract what the impacts. We will look at statutory sick pay and new family leave guidance that's coming in, and look at this. I've spoken about it briefly, this idea that we're going to ban 0-hour contracts. what that looks like. It's not a ban, it's a rule that's coming in. So we'll look at that rule and how that might capture other aspects of the workplace. And we'll look at the 6 months for employees to bring tribunals, what that impact might be, what you might need to do. Flexible working, of course, we already have that as a day one, right? So what is this new rule? How will it impact? And we look at the new requirement to prevent harassment, the new duty on employers to prevent harassment from third parties as well. So that's quite a big change that will be coming in. So without further ado, I will introduce you to Anabelle, and Anabelle will start to talk you through what the bill actually says about these aspects.
Thank you, Catherine. Really good introduction. And really, I would like to stress the point that this might feel a little bit overwhelming for some of you. As Catherine said, this is really to get you to start thinking about things on the understanding that you won't need to do anything drastic until at the earliest next year. So the first one, which is very important and probably could have a massive impact on all types of organizations, whether you're a large organization or a small SME, is the removal of the 2-year qualifying period to claim unfair dismissal. So currently, in most cases, you can dismiss an employee under 2-year service following a basic process, or in some cases very, very limited procedures. Obviously, something to always remember is that any discrimination claim is effective immediately, so you don't have that 2-year qualifying period. But in terms of unfair dismissal, what the bill is bringing is the removal of that 2-year qualifying period, and instead allow employees to claim unfair dismissal from day one of employment. What they are going to introduce is what they are calling an initial period of employment, or IPE, during which there will be a light touch dismissal procedure possible. However, this is still very unclear in terms of what the duration will be and what the process will be. So the key points really to think about is to ensure that any dismissal for employees will need to be done using that process within that IPE, and that obviously notice will need to be given as part of that, or within 3 months of the end of the IPE. So, Vicky, what do you think employers should look at for, since there's still quite a lot of vagueness to this?
Yes, we're going to have a theme going through all the way through this session, which is there is detail to follow, I think. But so there's a couple of key points I think to draw out here. So this initial period of employment opportunity is essentially similar to what we would describe as a probationary period, but it isn't the same as a contractual probationary period. So one of the things we'll need to think about is in a contract, it will specify perhaps shorter notice. That's typically what happens in a probationary period. None of that is going to change. This is just about the way in which we bring employees' employment to an end. So that relationship between the process we follow and our contractual obligations we'll need to think about, first of all. We don't know exactly what the IPE length has been. The government has signalled that they think is going to be about 9 months. That's their preference on this. So we need to see more detail on that. If I'm a betting woman, I think it will come out at being 9 months. What that means, therefore, is that the notice to terminate somebody's employment must be given within that IPE, within that period of time, and these kind of shorter processes that we can follow within that period will be available to us as long as the employment ends within 3 months of that IPE. So there's lots of numbers flying around, but essentially, if you've got somebody on less than 3 months notice, contractual notice, then actually you give notice within that 9-month period, then the IPE is available for you for the first year, is what it's looking like. Now, from a practical point of view, what that IPE gives us is a shorter process or a lighter touch process to follow. It looks as if there will at least need to be a meeting. So in that sense, it can't just be no. Sometimes people at the moment with less than 2 years service, we just terminate without any process at all. We'll need at least a meeting by the looks of it in terms of that probationary period. I think the key thing here as well to remember, though, is that we are only talking about dismissals relating to the performance or behaviour of the individual, that this sort of shorter process will be available. What that means is that effectively people will have much more protection from redundancy in the first 2 years of employment than they have now. It's not obvious on these changes that's being talked about. So if, for example, we lose, a big contract or a big client and we need to reduce our headcounts, traditionally up to now, we've worried less about the process that you followed to make short service employees redundant. We'll have to stop that practice. We'll have to go through a proper consultation with everybody. Now, some of you out there might be thinking, well, we do that anyway, it's the right thing to do. And then therefore you're ahead of the game in that sense. But for those of us that make the decision to change what we do, depending on whether somebody's got over 2 years service or less than 2 years service, in redundancy situations, but also in probationary, we need to make sure we're doing more process in a nutshell in that respect. So whilst we don't know quite a lot of stuff, there are things that we can do. Think about your probationary procedures. What are managers doing now to properly kind of give feedback so that actually if you do then have to introduce a meeting where you don't currently, that feels like a less of a big step. And to help with all of that, you'll need to make sure that we're giving good reasons to terminate somebody's employment in that early stage. So get more and more involved in probationary period discussions, that sort of thing. So again, it feels like less of a great big leap when these sort of kind of initial periods of employment come into existence. And you could almost go one step further back than that, which is thinking about strengthening your effectiveness of your recruitment processes. So actually you've got fewer situations where you have to bring somebody's employment to an end because they aren't the right fit from a conduct or a performance point of view, which resolves a lot of these issues in terms of the need for this additional process. And as I say, the other thing to bear in mind is just think about redundancy. Don't be thinking that you don't have to follow a process if somebody's got less than 2 years service too.
Thanks, Vicky. I think that's very important to talk about the proactivity. So being proactive about how you manage your staff will really help you and put you in a much stronger position to deal with these changes in employment law. So that's where it's great to have that, I'll put it in inverted commas, luxury of time to be able to prepare yourself and almost assess how effective your recruitment, your probation, your performance management systems are, so that you can, actually get ready ahead of time. Okay, let's look at another one. Now, this is probably, I think, the most technical, as far as I'm concerned, of the changes. It's around statutory sick pay. And there's a couple of big changes there. The first one is, you may be aware currently, employees who are getting statutory sick pay, we only receive SSP from the 4th day of absence. So we explain that as 3 waiting days until the 4th day and SSP kicks in. So this will go in the new legislation. Which obviously can have already quite a bit of impact, and we'll think about that in terms of, will it likely increase the level of absence in your organization, as people will be entitled to pay earlier. Saying that, there will be a second change, which is the removal of the lower earnings limit, which is currently £123 per week. It's actually increasing in April to £125 per week. Now, this will basically lead to a change in the way SSP will be calculated for lower earning employees. At the moment, it's paid as a flat rate, 116.75. From April, that's increasing to 118.75 per week. And basically, instead of having that flat rate, there will be a percentage of earning, which will be the basis for the calculation of the payment for lower earning employees. Now, the interesting thing here is you may think that in some cases, lower earning employees will actually get less SSP as they would currently. And I think what the thinking is that the removal of the 3 waiting days will offset the fact that the weekly pay of SSP will possibly go down for them. So there's a bit of financial juggling going on here. So Vicky, what to look at for employers in this area?
So in terms of the information that's still to come out, we need to understand this all important percentage. How is that going to be calculated? The government is recognising that the flat rate for lower earning employees obviously isn't going to work. Whilst there isn't going to be this lower earnings limit in existence any longer, there is still an acknowledgement that there are lower earnings employees, i.e. those that earn rather below the flat rate as it stands at the moment. So we just need that detail, which is going to be important, obviously, from the kind of financial implications point of view. The consultation on this closed in December, so it's going to be one of those things where we need to wait to see for the further detail on it. So on one level, you could look at this and thinking, well, actually, it's just an additional cost coming at my business and there's nothing more I can do about it. But it may well also give us the opportunity to think about how we manage absence management. And I would always put a call out for your return to work interviews. It's one of those things that I think it is one of the things that managers often miss doing practically, but it can really make a difference in terms of reducing the amount of kind of intermittent sickness absence, the coughs, colds, duvet days, it's a Friday, that sort of thing that goes on, which helps to manage down the overall cost. So I think that kind of putting that increased focus on good quality absence management will help to mitigate some of the cost that is inevitably coming at business as a result of this.
Thank you, Vicky. So again, proactivity is important here, trying to put in place some good, sound, consistent processes in your organizations to ensure that absence is managed well and fairly, but in a way that tries to deter the less genuine absences from employees. Right, let's continue in terms of the day right expansion. And here we're talking about family and bereavement leave benefits. So we already have in place a broad number of benefits for parents in terms of leave and pay. So they will basically extend what is currently in place. Paternity leave is currently entitlement that kicks in from 26 weeks service. This will be an attachment from day one. And parental leave will also move from 1 year service to day one right. Now, parental leave, in my experience, is not used often by parents. It's something that is not well known, but also it's unpaid. So obviously that is quite difficult for most employees to take leave that is unpaid. But as an employee, you need to be aware that you may have staff who request that leave upon joining from day one. The other change is around bereavement leave. So parental bereavement leave was introduced fairly recently, actually, but this will be extended to a more generic bereavement leave, which will go beyond parents, and basically it will look at a bereavement of a close person to the employee. There's still some definition to be outlined in terms of that side of things. The benefit will be for 1 week unpaid as a minimum. Currently, the parental bereavement leave provides for 2 weeks, and that's obviously only available to parents of a child under 18. At the moment, there's no change to the pay entitlements in this area. I just wanted to take this opportunity as we're approaching April just to flag that there is, separately to the ERB, there is a new neonatal care leave that is going to be available to parents from the 6th of April this year. And that's basically available to parents of babies who are admitted to neonatal care up to 28 days old and who have had a continuous stay in hospital of 7 days or longer. So these will allow eligible parents to take up to 12 weeks of leave and potentially pay as well. And that would be on top of any other leave that they may be entitled to, including maternity or paternity and so on. So this is separate to the ERB, but I think it's particularly relevant to flag this because I don't think many employers are aware of this coming in April. Vicky, anything to think of in terms of this expansion of family leave?
Yeah. So from a technical point of view, we just need to know exactly what the relationship to the deceased is going to be in terms of the eligibility to take this bereavement leave. So there'll be some sort of technical provisions that we just need to think about in terms of who is eligible. But I think it's probably about two things really from a practical point of view. Start updating your managers. And one thing I would say with this sort of thing is bearing in mind that that employees have got rights to be protected from being subjected to a detriment for having taken these rights. So just be a bit mindful of manager eye rolling around this sort of thing, because that could amount to sort of detrimental treatment if somebody says, oh, this person's always off, or, you know, for goodness sake, how many more types of leave? It's that sort of behaviour, which we might have some empathy for in terms of managers feeling this when they're managing their teams. But nonetheless, we need to make sure that that sort of behaviour is not being demonstrated. But also think about how this dovetails with your current compassionate leave policy or practice too. And I think there's a theme actually running through all of these day one rights point. I mentioned it in the context of probationary periods in this context versus contractual rights. Same applies here. And actually, when you think about if you do offer company sick pay that's over and above SSP, similar applies. You need to think about how these dovetail, because none of these changes will change what are your contractual or policy positions at, if they are providing more than these rights. You need to just think about those policies, how they relate to each other.
Yeah. So, I think it's important to think that we are all potentially benefiting from this expansion of rights as individuals, but as employer, there is some requirement to really be aware of what is available to your employees and to be informed so that you can deal with any requests effectively and accurately. Let's move now to something very different and which Catherine touched on earlier in terms of the banning, and really the banning should possibly be in inverted commas here as well, of 0-hour contracts, but also talking more and more about low hours contracts. And what we're looking at here is that there will be a duty to offer a guaranteed hours contract that reflects the hours regularly worked in a reference period, and that's likely to be 12 weeks for those workers who will qualify for that. There will obviously be also the duty to inform your employees about their rights into what is called an initial information period. So basically 2 weeks from start of employment or when they become a qualifying worker, or obviously from the date the law comes into force. So this really brings into the process an element of being clear as an employer about what is your duty as an employer in terms of the hours you're going to offer, and also ensure that the employee has a full understanding of their rights, and that includes the duty to provide reasonable notice of shifts and compensation in some cases where a shift requested is cancelled or moved or cut short. So there's really a lot to unpick here. I think Catherine said it's not really a ban. It's really a case of amending and restricting significantly the potential flexibility of employers to use workers across a whole varied work pattern. Vicky, could you bring a bit more clarity here in terms of what to look out for in particular in this? It's quite a complex area as well.
I'll certainly try. Again, the devil's going to be in the detail in some of this, but I think that the best way to look at this from a practical point of view now is to step back and look at what is it trying to address. What it's trying to address here is one-sided flexibility. So in other words, where us as employers have contractual terms that says essentially we can call people into work when we want to, we can change your shifts, we can give you more hours than we are obliged to give you. So in other words, we can call you in, but you don't have any minimum commitment from us as an employer. So that one-sided flexibility is what this is trying to address by giving team members more certainty about the contracts after a period of time in terms of how much they are likely to earn. So the idea will be this, that there'll be a rolling period, probably 12 weeks, that we've got to look back over and say, have we been consistently giving this employee a certain number of hours or more than we're contractually obliged to give them, and in which case they're entitled to a contract that's a new concept called a guaranteed hours contract. So in other words, what we're required to do is kind of give more certainty to the employee because they've been consistently working more than the contract says that they are necessarily entitled to. Now, what a low hours contract is at this stage, we don't know. We're waiting for the details on that. And so we need to kind of keep an eye on that. And this is the thing, I think, because it's all been called banning 0 hours, for those of us that don't use 0 hours, but use kind of a contract that says, Vicky, I will give you 5 hours a week, but actually I'm consistently working 20. This will be caught by that probably. Don't quote me on the numbers, as it were, because we don't know what they are at that stage. The same applies with contracts that provide for shifts that aren't certain. It's that one-sided flexibility again. So actually, if we are moving people's hours around on notice at the moment, then we'll be under an obligation to give some form of compensation for shifts that either cancelled or moved or curtailed in some way. What that looks like, I really don't know. Interestingly, employees will still be able to agree to stay on the 0 hours or low hours contracts if it suits the employee to have that level of flexibility, then they can still stay on it. But it won't stop us as an employer having process requirements to say, would you like one of these guaranteed hours contracts? And that's where I think we're going to see burden for us as organisations. There's quite a lot of process that we're going to need to put in place here. Now, exactly what that looks like, we don't know at this stage, but what it will require is record keeping. So that's one thing I would start to be doing now, is making sure you've got really good records of what hours people are working, so that if when you do need to put this process into place, you can get to that data quite quickly.
Yeah, I think on the administration side, there's potentially a big shift there for those organizations who maybe manage things very simply, and you may need to have more robust systems to keep track of all of this to help you to ensure that you work within the remit of the new legislation. Thank you, Vicky. So you might be relieved that the next section is slightly simpler and less technical. And basically what we're looking at here is the period of employees to bring an employment tribunal claim. So it's simple, but it might not be welcomed by employers. Basically, we're moving to currently what is typically a 3 months limit to bring an ET claim to 6 months. Now, there are exceptions to the 3 months currently, and in some cases, employees have a bit longer, depending on the circumstances of the case. But basically, 6 months will be the new default duration to bring a claim. Vicky, this seems pretty clear cut. Anything that we need to be aware here?
Well, I think you're absolutely right. I mean, it has sort of come in relatively late, so it might be a surprise to some on the call. Then there may well be that some people have been aware of the concepts of some of these things, but this is a relatively new change. So if you're thinking, oh my goodness, where did this come from? Don't worry, it's come at you relatively recently. I think the big question is going to be, how on earth are we going to cope with the backlog of claims, whether that's through ACAS and early conciliation or through employment tribunal systems? Because inevitably, if we think about the day one rights, potentially there's going to be more claims coming in there, but also people have now got longer to bring their claims, that then there may well be the situation that people will will bring claims where previously they missed that time limit and have just moved on in terms of thinking, well, that time frame has passed me by. So I think what that means is we need to think about better quality record keeping. So managers showing their workings, if you like, keeping records of their decision making in terms of any kind of employee relations issues, performance, conduct, absence management, requests for any statutory leave, those sorts of things. Keep those records, because of course if a manager leaves your business and an employee brings a claim in relation to those managers' decisions, you're still going to need to get to those decisions even though the manager has left you. So because you'll still absolutely have to deal with those complaints. So I think it is more about record keeping at this stage, and that applies both to formal processes but also informal processes. So remember, this could apply to things like claims for constructive unfair dismissal, where perhaps we wouldn't have seen as much about that as if we would have seen it if it was a process that we initiated, like a disciplinary or something along those lines. So I think this is about kind of keeping better records is the practical thing here.
Thank you, Vicky. Just one thing around record keeping, something that comes up more and more with clients is subject access requests. So some of you may have had to deal with that. And basically what this means for you as employers is to ensure that your record keeping is in line with what you would be prepared to divulge in a tribunal. So be very careful about the type of record you keep, and that they don't place you in a tricky situation if the dispute escalates to a tribunal claim. Thank you. So let's move on to something possibly a little bit less heavy. And here we're looking at flexible working requests. So this is the right to request flexible working is obviously not new. It's been in legislation for years. In our experience, it's used quite a lot in different sectors, but obviously it needs to be carefully managed to make sure it is done in a fair and lawful way. So the bill is it's not a major change, I think, but it's a bit of a tweak of what we have currently. And basically what it specifies is that a request for flexible working will only be able to be reasonable to do so. And I hear you think, well, what is reasonable? And Vicky will touch on that as well. But in addition, it still requires the justification for any refusal to be aligned to the current 8 grounds that are suggested as part of the current framework. And for those of you who are not familiar with that, we're talking about grounds such as the burden of additional cost, the inability to reorganize the work, the inability to recruit additional staff, the detrimental impact on quality or on the ability to meet your customer demands, or whether there's actually insufficient work for the periods requested to work by the employee, or whether you are making any structural changes as well. It's really important to still use those 8 grounds as a basis for your consideration of the request. The requirement to have written notification of the reason for refusal, I would expect that currently this is still something that most employers would do anyway. So I think in terms of best practice, I think that still aligns with that, but it's something that will be a right for the employee to have. So a slight expansion of that right here. Vicky, anything to add on this?
So we're still waiting for a bit of detail on this, I think. So on exactly what are going to be the further regulations on handling the request. At the moment, we've got an obligation to consult, but that doesn't necessarily require a meeting, although there is an ACAS code of practice that does recommend that. So we might see a little bit more kind of expectation to follow ACAS code if it gets kind of turned into regulation almost, as it were. Don't know, but that seems to be the direction of travel. And again, I think if you think about the general direction of travel of a Labour government around processes, that they tend to require more process from an employee relations point of view historically than a Conservative government would have. I mean, for those of you who have been around this space for a long time, you may remember the statutory procedures which related to things like dealing with disciplinaries and what have you. That was very process heavy. So we might see a little bit more going in that direction, I suspect. I think the key here is this point about whether it is reasonable. So what this is shifting is from a test that is broadly subjective. If an employer attributed one of those 8 reasons that Anabelle you just ran through, as it stands at the moment, it is quite difficult for an employee to challenge that. But now it will be much more of an objective test. So in other words, an employment tribunal could get in the middle of that decision making and say, actually, is it reasonable to say that responding to my request for the employee's request for flexible working, it is right to say that there is going to be a burden on additional costs or whatever reason is being used. So in other words, we've really got to show our workings here. I think there might also need to be a kind of balancing of interests. So negative impact on the employer of granting the request versus positive benefit on the employee of granting the request. Where does the balance of the reasonable decision lie, which will be a change to how we've handled requests in the past and currently. So there's going to be kind of better quality decision making being needed here, I would say.
Absolutely. The other thing to add is the need for consistency. So you will need to ensure that as a business, you are consistent in your acceptance or refusal of a request, so that it's confirming that your reasonableness applies irrespective of the employee who has requested it.
I agree, but that doesn't allow us to say we never agree to allow people to work from home on a Friday or something like that, because you'll need the case by case decision. So consistency for sure in terms of making sure you're relying on your 8 reasons, but making sure it properly applies to the set of circumstances.
Absolutely.
I think the other thing we need to think about here is making sure that we deal with situations promptly, because there isn't quite the timeframes that there would be in other instances, and we have seen delay creep in dealing with these things. So and of course, when there's more decision making that's needed, that can create delay. So there's going to be a tension, I think, with that we need to think about.
yeah. And ensuring your managers who tend to receive the request are aware of
Yeah.
the rights and the need to approach things in a particular way. So again, some training required to ensure that your managers are informed and equipped to deal with those queries. So let's move to one of our hot topics of the last few months. We have been really busy at Worknest supporting clients in understanding the new legislation that came in October around the prevention of sexual harassment at work. And there's more to come on this side of the bill. At the moment, the legislation requires employers to take reasonable steps to prevent sexual harassment at work. This will evolve to a duty to take all reasonable steps to prevent sexual harassment at work. This will also touch on the prevention of harassment by a third party. And I think in this sector, it's particularly relevant. A lot of your staff will be either dealing with the general public or a number of obviously customers, clients on site. It's really important to look at the prevention of harassment by third party to your staff. And this will expand beyond sexual harassment, but actually harassment in relation to the other protected characteristics. And as you may be aware, there are 9 protected characteristics in the Equality Act. So this is really something that employers need to take a proper look at and start looking at what these all reasonable steps mean in the context of their business. The other important point is that a report by a worker that sexual harassment has occurred, is occurring, or is likely to occur will be a protected disclosure. And what we mean by that is that it would fall within the remit of a whistleblowing case, and your whistleblowing policy would need to be put in place and used to deal with cases like that. So that puts some specific requirements on you in dealing with those complaints, which might be slightly different to your current grievance or complaint procedures. Vicky, what can we say in terms of those reasonable steps? Any
Yeah.
clarity on this?
Yeah, absolutely right. I think what amounts to all reasonable steps is something that is so difficult to be able to put your finger on. So if we think about the reasonable steps defence that came in or that was required for us to think about in terms of the duty to prevent that came in October, there was quite a lot of detailed guidance from the Equality and Human Rights Commission around sexual harassment. So I think it's going to be that plus really in that respect, because the sense of all is really, from a legal point of view, it always kind of creates this sense of there is nothing more we could feasibly do. So this is about both quantity and quality of the things that we are doing. So that sense of, for example, a briefing and training our employees once in a while isn't going to necessarily be effective if actually we can see behaviours that are going contrary to that training. So there was a case that was talking about training going stale a few years ago because training was given, then there was behaviours and nothing was done about those behaviours. So that indicated that the training didn't do its job, sort of thing. So there's going to be that constant refreshing required, making sure that we're communicating, bearing in mind that this also applies to third parties. So we're going to need to think about communications out to our third parties. Now you'll have seen, and you may well have in place things like notices up in public areas and that sort of thing. But are you writing to suppliers, people that you're working with, that sort of thing, to require them to kind of be aware of that? It's going to be all of those process steps that are needed, as well as taking those pulse checks. So if you don't already, think about things like your engagement surveys. Are you asking about what the working environment is like to see whether or not there is the possibility of harassment happening in the organisation? In terms of the protected disclosure point, what it was actually trying to address was the increasing practice of when people were settling complaints, putting kind of gagging orders or confidentiality provisions to stop employees or former employees talking about what's happening to them. But there is some unintended consequence that I think, Anabelle, you've touched on here quite rightly, which is if you have a whistleblowing policy or a whistleblowing line, you may well need to be thinking about how do complaints get raised practically. Ideally, we would want them to be being raised to us so we can investigate and deal with them, rather than necessarily going to a confidential hotline type thing where actually you don't get the detail. Whilst it's important they're raised, however it's dealt with, just be aware of that, because that might impede how you can practically look into these things. So it's just one of those things to be aware of at this stage. But kind of raising awareness, making sure that people are given and encouraged, given the opportunity and encouraged to speak up about concerns so that you can nip them in the bud is key, particularly in light of the fact that we're talking about sexual harassment or harassment that's occurred, is occurring, or is likely to occur. So this is where the temperature is being raised. It's not happening yet, but I think there's a prospect of it, is what's being talked about here. Anabelle, you rightly also identified that we're talking about workers as far as the protection from whistleblowing. Remember, that's a broader group of people than employees that we've been talking about in a lot of instances as we've been talking through this webinar. The protection from whistleblowing detriment applies to that broader group of people that is workers too.
Okay, so quite a lot to get your head around in this area, and it's something that obviously you can get support with by the support that ECA provide to all their members. Okay, so we've identified a few other things to look at. Vicky, do you want to do a quick run through those and highlight the ones that may be of particular interest for our delegates today?
Yeah, of course. So these are quick fire things just to be aware of that are coming down the track. There's additional protection for employees dismissed during pregnancy or during or after family leave. Further sort of provisions around preventing discrimination. So again, if you're looking at either dealing with issues after family leave that relate to performance or absence or redundancy situations, just be aware that there's some additional protection. Likewise, either during pregnancy or during leave too. Redundancy and contractual change. This is around the collective redundancy, so larger scale redundancies. Now, it used to be the case when we're talking larger scale redundancies, it was 20 or more at any kind of workplace. That is changing to 20 or more across the business as a whole. So if you are a multi-site organisation and you've got lots of redundancies going on at any one point in time, then the duty to consult collectively, so that's either with the trade union or with your elected employee representatives, is going to be there where it isn't currently. So that's kind of doing some horizon scanning across the whole of your organisation, and it's 20 or more in any 90-day period. So think about it as a rolling period in that respect. Following the P&O situation a few years ago, there was a lot of talk about fire and rehire. That is still something that is going through. I think if that is something that you're considering doing, take some advice on that to understand exactly what the provisions are in that respect. And we'll also see some additional trade union related rights too, in terms of the rights to a statement of trade union rights, more rights for trade unions to have access to workplaces, and that's even if you don't recognise a trade union in that respect. There'll be a little bit of simplification around trade union recognition and some more time off rights as well, and also potentially changes to industrial action as well. Again, if this is an area that's of interest, I think we've been exploring whether or not we do a specific industrial relations focused session where we can look at these in a bit more detail. But just for now, one of those important things to just be aware that these are changes that we haven't touched on in detail today.
So plenty more. So watch this space. Over to you, Catherine.
Catherine, you're just on mute.
Oh.
You've got the
Thank
t-shirt for
you.
2 minutes.
Yeah. Thank you very much, Vicky and Anabelle. I think, as you can see, there's a lot coming down the road for employers to get their head round. Need to look at recruitment, managing absence, probation, flexible working. And, you know, Anabelle touched there on the harassment rights coming in. If you don't know where to start, there are things on the website. We've got a risk assessment and an action plan on there, which is always a good place to sort of sit down and start to plan out how you might be able to tackle that aspect of the employment law. I mean, it's specifically at the moment in relation to sexual harassment, but as you can see, the Employment Rights Bill is going to stretch that out to all forms of harassment. So it's a really good place to start. So do have a look on the website. There's loads of support on there for you and an overview of the Employment Rights Bill. But we also have our Employment Relations Helpline, so you can contact us by email or on the phone number on screen, and we'll get back to you and support you on. We'll continue to update the website as more detail on the bill comes through to keep you updated on the developments and guide and advise you through implementing the processes that we've discussed today. We don't have much time for any questions, but if you've got anything quickly, you can pop that in the chat. I've put up there the QR code for you so you can get your certificate for the Employment Rights Bill, but you'll also get an email through to get that. So if you don't manage to work that now, you'll receive an email with the QR code. Right, so we've got 3 minutes left. So I can see a question up there. I'm a self-employed building surveyor and currently get work from one company. Does the bill affect my contract, which was written over 15 years ago? Circumstances have changed, not always to my advantage, especially regarding the amount of admin I seem to have to undertake. So I think that seems to be a question about being self-employed and having a contract for 15 years. Does the bill affect that contract? It's quite a broad question, actually, that one, because we've talked through so many different aspects of the employment bill, and we've tried to indicate where the bill impacts employees and where it extends out to workers. And actually, one of the interesting points to the bill that we haven't covered today is that the bill is also going to look at the status of workers. It's a really complex area. It's on the list. It's on the longer list, if you like, because it's a really complex area. And there's employment law, there is case law. You may remember Pimlico Plumbers had a recent case law on whether they were actually self-employed or an employer. So there's all that to untangle, plus the tax implications. So whether the Employment Rights Bill will get to setting the single status is unknown. It's on the longer list, which is why we didn't explore that in any detail today. I don't know whether Vicky or Anabelle, you've got anything you want to add to that.
I think you're absolutely right. There is the aspiration to extend rights that are provided to employees to workers, but we've not got any detail of that at this stage. So if you think about it as layers of an onion, if you like, in terms of employees are closest to their employer in terms of their obligations and the kind of contractual sort of responsibilities and rights. Then the next layer out of the onion is workers, which is there are some rights and protections, but not, for example, the unfair dismissal protection. And then the outer layer of my onion is the genuinely self-employed. Now, there are far fewer protections and rights, and very little that we've talked about today will apply to the genuinely self-employed. So I would start, though, with the question, if I or people in my team we're holding them out as genuinely self-employed, is that correct? And that is a very fact-specific test. So I would start there in terms of the question, the question that we've been had: am I genuinely self-employed in terms of the relationship that I have with the person that engages me? And if not, am I a worker or am I an employee? What's on the face of any document is the starting point, but it isn't the end point. It's what actually happens in practice. So that, I think, is an important question to start with, to answer a question like that.
And if you don't know how to answer that question, there is guidance on employment status on the website that you can pull off. It's a complex area, and you can read through and try and work through your status. It's 14 seconds to go, so I want to thank everyone for joining us today. Thanks Anabelle and Vicky, and as we've discussed, we may look to roll out some more webinars once we get further detail on the relevant aspects. And so enjoy your Fridays, everyone, and thank you for joining us.
Thank you.
Thank you very much.